The next case asks what courts should do when two parties interpret a term in a contract differently. The case of Frigaliment Importing versus B.N.S. International Sales Corporation comes to us from the Federal District Court in New York City because the plaintiff, a Swiss company, is suing an American company for breach of warranty. The underlying issue, as Judge Friendly writes, is what is chicken? The buyer, Frigaliment Importing Company, announces via its New York agent that it was looking to buy chickens of particular weights at particular prices. The seller, B.N.S. International, agreed to sell the buyer dozens of tons of U.S. fresh frozen chicken, grade A, government inspected, eviscerated, of two different weights at the set prices. The smaller birds that it sent at a higher price were roasters, quote, young chicken suitable for broiling and frying, unquote. But the larger birds were, quote, stewing chickens or fowl, which the Swiss buyers rejected. They said that the word chicken referred only to broilers and fryers, and not to the old hens that seller had sent, which it called fowl. Even so, the seller sent the second agreed-upon shipment of chicken to the buyer the following day. The buyers then brought suit in the Federal District Court in New York City for breach of warranty. We're reading Judge Friendly's findings of fact and conclusions of law from the trial court. Judge Henry Friendly is an incredibly famous judge whose life and death are memorialized in a Harvard Law Review essay called A Lawyer's Death, which is included in this module's reading materials. Judge Friendly runs through a number of arguments that persuaded him that the defendant, sellers, should win, given the two parties' different interpretations of the word chicken. First, he found that the seller had written a telegram to the buyer's agent to ask what chicken meant, to which he answered that any kind of chicken was acceptable, and had further clarified that the term was equivalent to the German term Huhn, which does include stewing chickens. Each party also brought in expert witnesses to testify on the meaning of chicken, but both sides' experts testified that when they wanted to make sure they didn't get foul, they would add clarifying language to specify that they wanted broiling chickens. The Department of Agriculture regulations to which the contract referred also included stewing chickens among chickens. Finally, Judge Friendly looked at the price that Frigaliment offered for the larger chickens, which was 33 cents. He found that of all the things that the word chicken could describe, only stewing chickens had a market price that matched at the time the contract was made. Frigaliment therefore knew, or should have known, that it could only expect stewing chickens for the price it was paying. Section 202 of the Second Restatement of Contracts encapsulates some of the principles that Judge Friendly uses in interpreting the contract. He interprets it in the light of all the circumstances, including the prevailing market prices for different types of chicken. He interprets the contract as a whole and tries to determine what the, quote, generally prevailing meaning, unquote, is through the use of dictionaries, regulations, and expert testimony. And he examines the extent to which Frigaliment acquiesced to B.N.S.'s performance to determine if they had consistently objected to the stewing chickens. Judge Friendly's arguments about what each of the parties knew or should have known corresponds with the rule from Section 201, subparagraph 2 of the restatement. Party A's interpretation of the contract is binding if Party B knew or should have known Party A's interpretation, and not vice versa. In this case, the buyer should have been aware, and may have actually been aware, that the seller was not, quote, a member of the trade, unquote, and would not know any meaning for the word chicken other than the usual one. In a latter case, Judge Friendly suggested that this case should have been decided under the peerless doctrine. As you'll recall, that is the English case where the court said there was no contract at all because the parties had been referring to different ships by the same name, peerless. In the peerless case, there was no reason to think that one party was right. In his actual opinion in this case, Judge Friendly suggests that the correct reading of the word chicken in this contract includes stewing chicken. His later decision suggests that this case did involve true equivocation, where there is no reason to decide that one party's reading is any better than the other's. This equivocation belief would mean that there was no contract between Frigaliment and B.N.S. Even so, the end result would not have been very different, as Judge Friendly would have still ruled for the defendant seller, who had reasonably relied on the plaintiff buyer's promise. Another doctrine that lurks in the background of this case is contra proferendum, that we read ambiguous contractual terms against the party who drafted them. Here, Frigaliment chose the word chicken in phrasing its order, and B.N.S. reasonably provided something that coincided with an objective meaning of chicken. The drafter would have the burden of showing that this was not within the meaning of the contract, and it did not successfully do this in this case. So, here's a quiz. Imagine that a young person contracts to buy 100 mice from an older person. When the older person delivers 100 live mice instead of 100 computer mice, the young person sues for breach of contract. Which pieces of evidence would help the older person's case? Well, A and C would help the older person's case. C falls under Section 202. The young person should have known that the older person interpreted the agreement differently. A provides an in light of all the circumstances argument that the older person reasonably concluded that the young person wanted live mice to feed his cats. B and D both provide reasons why the older person should have known that computer mice were wanted, and so they would help the younger person's case instead. We have seen that courts use a variety of methods to determine the meaning of contract provisions. Dictionaries, regulations, maxims of interpretation such as contra proferendum, and the economic context are just a few examples. Where two parties disagree, Section 201, subparagraph 2 of the restatement says that the courts can look at which party knew the other's interpretation